William McClendon for the defendant, Anthony Beale, who appears via Zoom from a separate location.
Any announcements at this time, Mr. McClendon?
Your Honor, I'd like to set these for a prelim. One of those cases is a misdemeanor only, and we were just kind of tagging it along because of there's so many of them. But I think either one long prelim or three separate prelims, but I don't want them to be ran together because they're kind of factually different. Each case
Well,
is.
some of them have different victims alleged, yes. But now, Mr. Beal, didn't you have? I was thinking we had something else with you on my calendar coming up, or that we'd just.
There's That's a different issue. It's a divorce between him and his wife, which is being, uh, well, they're not getting divorced anymore, but that's another issue for another
Oh,
later on.
that's not where I was seeing it that I recall. Missy, did you remember any other criminal cases?
No, Judge, just these that are on the docket today.
Okay, well, that's more than enough.
No, the felony in the first case, 23 CR 157, is allegedly aggravated assault on his, I believe it's his father-in-law.
Okay.
The witnesses are the same in that for the most part, and 24 CR 96, wherein the felony is his wife, who is also a witness in 23 CR 157.
They're supposed to be having no contact in these cases as a condition of bond, right?
Yes, Your Honor, and that was something I was also wanting to address today.
Missy, how do you want to set these? Giving him a
Well,
separate prelim for each one,
I have June 28th available in the afternoon.
the whole afternoon,
I do have it available
starting at what time?
at 1 or 1:30.
This case doesn't start loud. It starts heavy. Multiple cases, multiple victims, multiple protection orders. When a judge pauses and says that's more than enough, that's not sarcasm. That's concern. This isn't one bad night. This is a pattern the court has already seen forming.
If ever we need to start it at.
Let's make it 115. These are all set, but we need to also be taking care of that misdemeanor because that's 4 counts of violation of a protection order. So I don't want that to get lost in the shuffle.
Right.
Okay, that's what we'll do. We'll reserve the whole day for prelims. We'll do one after the other.
Starting at 1:30,
115.
115.
1:15. Okay.
And you said there was something else you wanted to address?
Your Honor, my how do I do this without incriminating my client? Your Honor, he'd like to be let off bond, or have the no contact order with his wife dropped, so they can pursue couples therapy. They have a counselor arranged. I had this information from his wife, who figured out who I was his attorney um, via the courthouse.
Actually, Your Honor, his wife did contact me also, indicating that she would like to have contact in the therapy because they have children that they have to get along for, and she insists that Mr. Beale is a good father. He has some issues, but he's a good father. He's good to their children. She wants to be able to work with him, and she believes that the counseling will assist in that.
He's got an ag assault charge pending against her, an ag assault pending against his father-in-law, 4 counts of violating a protection order against her.
The aggravated assault against her.
Whenever couples therapy comes up in a domestic violence case, courts have to slow everything down. Not because therapy is bad, but because reconciliation can be dangerous when violence and control are already part of the story. Wanting contact doesn't automatically mean it's safe.
It's against complicated situation, but it's not against her.
All right, well, I'll just look at him in 56. violation of protection from abuse order. And she is listed as the victim in each of these, is she not? I'm not saying that she is or that the charges are right, but let me look at that.
It just says that it's a violation of the protective order. It looks like,
Okay.
it looks like on December 24th, he sent a text to his wife. On December 25th, he sent a text to his wife. It doesn't appear that there were any, these were texts, these were not in-person kind of threatening situations, Your Honor.
Telephone or text, but that's still a violation when you're told no contact. Now then, let's look at the other one, 57, aggravated assault with a deadly weapon and reckless driving.
The victim there appears to be a Jared Everly.
Is that her father?
No, her father's Mr. Simon, I believe.
All right, there's a Jared Everly where he was allegedly put in reasonable apprehension of immediate bodily harm with the deadly weapon, to wit, a truck. And then there's a reckless driving. 96, criminal damage to property of felony. I believe that is his wife's telephone, if I remember correctly.
That's correct,
Yes,
Your
Your
Honor.
Honor.
And then a domestic battery. I presume she's the victim. It's in violation of a protective order and criminal trespass. And that was in March of 24. And that brings us down to the other 157. That one dates back to
That's the father-in-law issue.
aggravated assault with a deadly weapon and disorderly conduct. Oh, the deadly weapon in this case was a hammer. Allegedly took a hammer to a Joseph Simon on July 8th of 2023 and committed disorderly conduct by fighting words.
Listen to how the judge reads these charges. Calm, methodical. That's intentional. Because when you strip away excuses, what's left is escalation. Texts, vehicles, weapons, repeated violations. Courts don't react to promises. They react to patterns.
But the babysitter got a PFA against him too, didn't she?
At one point, I don't know what the status on that is, Your Honor.
And then there was some incident about him flagging down the school bus and jerking the kids off by the arms and dragging them out.
I don't know where that come from, Your Honor, but that was.
I'm not aware of that, Your Honor.
I'm not aware of that either.
I was supposed to get my children for Easter weekend, and my wife changed her mind, and she wasn't going to give me them until a certain date. Thursday was exchange day for our children. I wasn't going to get them till later on. They're my children. That was my time with them.
So you flagged down the school bus and jerked them off of it?
Didn't pull them off there like you're trying to insinuate I did.
Oh, okay.
I went and stopped the school bus, got my children off there. Then we went to the babysitters where our youngest son had, and went inside. And that's where I'm being charged with the criminal trespassing.
This is where the defendant hurts himself the most. Every interruption, every explanation, every let me just say tells the court the same thing. He doesn't respect boundaries. And if you can't respect boundaries in court, that matters everywhere else.
I don't know.
Mr. Bill, I need you to stop talking now. Sorry. I don't want you to incriminate
So
yourself here.
is that where the extra case is coming from that I'm thinking of? That there
Yes, Your Honor.
criminal trespass against the babysitter that's not among these?
Yes, Your Honor.
So there is a fifth case out there.
No, there's not a fifth case out there.
I still think I saw one besides the ones that somebody else mentioned there.
I believe that's where the 96 case comes in.
No, I don't think so.
Well, these are the only four that they gave me files on, Your Honor.
These are the only ones in Greenwood County that I am aware of.
You don't have anything going through city court, do you, Mr. Beal?
No, ma'am. Not that I'm aware of.
Okay. Well, I'm not going to modify the bond at this time, but I will tell you if the parties are each involved in individual therapy, and when their therapists individually think that they can take on therapy together, I will consider that, making no promises. But if you look at these charges, it looks like these two are dangerous together, that they just, I don't know what trips the emotions, but they just keep racking up these charges. And now all of a sudden, when they're supposed to be having no contact, they're wanting to get together. They've dropped their divorces. They've each filed a divorce. They're wanting to drop them. And
Judge doesn't say they're evil. She says they're dangerous together. That distinction matters. The court isn't punishing love. It's responding to chaos that keeps producing criminal charges.
Your Honor, to shed a little light on the situation. Months when she first dropped the divorce, it was so we could work things out to be a family. She
okay.
immediately looked at the time frame. She filed the divorce, then turned around, filed the PFA, and around that time frame is whenever she got caught being with somebody else when we were supposed to be working on things to be a family. Whenever I caught wind of that, that's when I filed for divorce. But just as Mary Ann and Mr. McClendon say, we have children together. It's in our best interest to do what's right for everybody.
So you're both wanting to get back together as a family, a couple and a family.
That's the end. That would be the ideal end goal. It's not our children's fault. They didn't ask for this. They deserve to have mom and dad. But
And did you say you had dismissed your divorce action?
I'm not yet. I don't want to dismiss that until the way everything's gone. As you can see from my charges, Your Honor, there's nothing worse than a scorned woman. And I want to make sure, I want to take the necessary steps, not leave my.
This moment is uncomfortable. Blame shifts. Accusations come out. Sympathy mixes with anger. But notice something important. Accountability never lands. Everything is someone else's fault. That's exactly why judges get cautious.
So you're going to keep me from my children?
Well, until we sort through this at the prelim, June 28th, 1:15.
William, step up.
Judge, if
William.
What are you saying, Mr. Bill?
I told William to step up and speak for his client.
Okay, hold on,
I'm
Mr.
trying.
Bill.
I'm
Everyone,
trying to
hold
listen.
on. I think I'm still in charge of this courtroom.
Obviously, and you obviously like it too.
Mr. Bill, I have put up with a lot with you over the course of these hearings. You always seem to take over or try to. And I've made these orders.
Family. What do you expect?
What was that?
I said, this is my family we're talking about. What do you expect?
Well, I'm not going to get into that with you, but if you want to try to resume contact, it would be good for you at the next hearing to bring in a statement from a therapist that you're going to therapy and that it would be a good move to start going to therapy with your wife. But from what these files show, you and your wife are not good together, that somebody's going to get hurt. Now, that's just what it looks like. I'm not prejudging anything. But if you look just at the paperwork, so go to a therapist. You and your attorney can talk about it. Go to a therapist and see if the therapist can give you something to show that you're not a danger to your wife or your children. Or her dad, because one of these says you were committed ag assault against her dad and someone else. So
I try my damnedest to be a good dad. And if her father thinks it's right to commit insurance fraud, I don't want my children being taught that way.
all right. Well, you talk to the therapist, you talk to your attorney, and we'll take this up June 28th at 1:15.
William,
Yeah.
speak up. I'm a dad.
Well, what do you
Mr.
what do you
Mr.
want
Bill, Mr. Bill, as your attorney, I'm gonna have to ask you to just please stop talking. You're digging yourself a hole, man. Please stop. Your Honor, I would just ask that you take notice of the complaints that are filed, and none of them list the children as witnesses. And therefore that we not have the no contact order against the children.
But my understanding from what I recall of the affidavits to support the warrants, and what I've heard in these hearings, it's my recollection and belief that the children were present for most, if not all of this.
I don't think that's true.
Miss Shirley, are you indicating?
I don't believe that's true, Your Honor. They may have been on that one, but I don't think they were on any of the others.
Okay.
They were present during the Easter one.
Mr. Bill, please.
That's the only one.
The Easter one is the one at the babysitters.
Yes, Your Honor.
All right.
I was told I was putting them in danger, but I wasn't trying to get a kid out of the back seat of a moving vehicle.
Like I said, talk to your attorney, talk to a therapist, and we'll see if we can put any more resolution to this June 28th at 1:15. That's 30 days out. All right, we'll be in recess. Mr. Beal, you are excused.
Court limits contact with children. That's never about punishment. It's about risk. Judges don't make that call lightly. They do it when the environment itself has become unsafe, emotionally or physically. The case isn't over. But the message is clear. Therapy first, proof second, contact last. The court isn't saying never. It's saying not like this. And until the behavior changes, safety comes before feelings.